there is a progressive kind increase every year over the past 3 years. There is, of course, a slight deviation, I think, in 2013-14, where you'll see a little decrease on registered claims. That has to do with the fact that registration of claims is subject to uncontrollable things such as, for instance, postal strikes and things like that. In that year, we had a postal strike, which is why you're seeing a little decrease. But back to the slide itself, right up there, 2012-2013, you'll see a plus 2.1% increase. This is an increase on the previous financial year, which should have been, 2011-2012. Now, in terms of registered claims to the contingent liabilities, that was the addition, 6.9 million. Then the next financial year, you'll see that slight deviation that I spoke about, which is 5.9 billion. And then the third year, 2014-15, 12,670 claims, and an increase of 21.4%, giving us 9.5 billion. You'll see as you go down, or rather, if you advert to the financial report that we disclosed at the end of the financial year, this 9.5 billion would be part and parcel of the figure that we finally reported at the end of that year. Then when you look at the actual number and compensation payments, I'm looking now at column 2 there on the very same slide, you'll see there the payment. This is about payments. 3,773 payments in 2012-2013, amounting to 209 million. 5,056 compensation payments, an increase of 41%. This talks to the progression I was talking about in rising terms, despite the deviation in terms of claims that I'm showing in the column above. Then 2013-14, 296.5 million. 2014-15, 5,317 claims, payments, increase of 2.02%, totaling 2,025 million. Then legal costs themselves, last column there, over 3 years, a rise, 165 million, 291.3 million, up to 240.2 million. Next slide. Chairperson, this slide talks to the methods of payments themselves nationally. The issues that are being highlighted there is the difference in the main between settlements and court judgments. This slide is simply telling us that a lot of our matters actually end up in court. In other words, what we pay is as a result of court judgments rather than settlements. Now you will see 2012-2013, the number of payments, 1,144, court judgments, 2,629, a percentage of 69.7% derived from the total figure of 3.773. And just below there, you'll see the amounts, 42 million, 2012-2013, 167 million in terms of court judgments. You see that difference, we pay a lot more. And then the total would have been 209.9 million in 2012 and 2013. Then as you go down, you see the same dynamic, an increase throughout with that totality in 2013-14, 296 million, right up to 2014-2015, 302,558 million. Now, the question might arise as to if we're paying so much, perhaps in terms of court judgments, why go to court at all on some of the matters? Yes, it's true. But before matters are actually defended, serious consideration is taken into account. But one of the issues that would necessarily push a matter being defended in court would be things such as disagreements on quantum. Sometimes we are forced, or in most cases we are actually forced to defend matters purely to fight quantum. But of course there is also the dynamic of a strong case on paper, and when the crunch happens in court, your witness is crumbling, then things happen, and an adverse outcome is the result. But the slide is also showing that there's a lot of matters that are also settled. And in settling matters, there is a big issue that can be noted. Settlement invariably involves negotiation and even saving in most instances. That is the picture then, Chairperson, in terms of costs and payments. And maybe let me just make this remark. Within payments themselves, especially settlement, there is cost as well, because as you settle, you'll also be looking at cost as well. Then, the next slide, please. The challenges and solutions. Chairperson, I've alluded to the existence of an office called the State Attorney. The State Attorney is basically the attorney for government. Currently, what we don't have, and which is what you would see in a normal client-to-attorney relationship, is what we call absence of cost visibility. Now, that debate that you see set out there is trying to address that, because the point we're trying to make is that once we are able to see costs and track costs, then we'll be able to make rational decisions around the cost and progression of any single matter. And the other thing is that at this point in time, we do not even have a breakdown for various categories. I've mentioned that we have labor matters, we have criminal matters, and so on. What we see at the end of each month is just global accounting, so on. But what we're doing together, or rather as SABS, was to initiate a team to ensure that we get to that point where we're saying we have cost visibility as a principle on each matter as it progresses, and also cost visibility for all categories. What is happening currently is that all invoices are received from the Department of Justice for refund of legal costs paid by the State Attorney on behalf of the department. And what we want is that eventually all these have to be certified by legal officials who instructed the State Attorney to perform the work from the onset. The main aim, of course, is to ensure that visibility is attained as and when each case progresses, so that legal costs are monitored properly. Basically, it also means we'll also be able to monitor the ratio of legal costs as against possible capital paid as compensation. In other words, we want to avoid the anomaly of having to pay a lot more on cost than what we pay in capital. At this point in time, we've already done changes on the Polfin system to ensure that this principle is attained, and we've started a pilot in the Northwest Province as well as at head office. Now, the rationale, of course, speaks to desirability of continued litigation and cost, and talks to really cost effectiveness. Next slide. Or before I go to that next slide, this is an issue that we've already put before the Department of Justice, and as part and parcel to improve our issues on litigation and management thereof, we have a bi-monthly engagement with the Department of Justice. It's an engagement that has the blessings of the Director General there. And the primary intent behind it is to unlock blockages that seem to find existence within state litigation to practically bring cost effectiveness and quality into state litigation. Now, one of the problems that we are encountering at present is that we see the increasing use of correspondence and counsel. Now, I'd like to believe that it has a lot to do, I guess, with the times we're living in. The State Attorneys Act dates back to 1957. I do not think it really anticipated that we'd have this kind of thing happening at some time in the future. But as part and parcel of that engagement with State Attorney, we're also participating in the initiative that has been started by the Department of Justice itself on the transformation of state legal services. And Chairperson will be aware that one of the issues that they are trying to address there would be proper capacitation of that office of the State Attorney. And we are currently participating in a survey that was initiated by the Public Service Commission on the quality of service delivery that the Office of the State Attorney is offering to departments. We've done inputs into that process, and we've now been invited to hearings around it, all directed at getting quality into state litigation. The regulatory framework itself poses challenges. One dynamic we've picked up is that artificial costs are incurred in an opportunistic way, or rather as a result of certain opportunistic practices. The law is such that at the present moment, when you sue the state, you sue the Minister of Police, whose principal place of business is in Pretoria. So what is happening is an incident would happen in Cape Town, then people use that provision to actually sue us in Pretoria. So in practical terms, it means when we go to court, you can take a whole team from Cape Town to Pretoria. So that increases costs in an artificial fashion. So we've made a proposal, because part of the effort to improve issues around litigation as part and parcel of that transformation process is a process that is looking at the legal framework itself. We have made proposals in terms of amendments to the Act, the Institution of Legal Proceedings Against Certain Organs of State Act. And one of the amendments we want there is an amendment that will force people to sue us where an incident is happening. Chairperson, we have to admit that we're a public service, and one of the problems of a public service is red tape and protracted processes. So one of the things we are looking at currently is internally to shorten our own procedures. For instance, there has been a practice, and I think it flows from the old Treasury instructions, whereby you can't even take a simple decision whether you'd like to defend a matter or not without consulting the State Attorney. Now let's make a simple example. State vehicle reverses into somebody's parked vehicle. That would have meant you simply have to consult State Attorney before you make a decision whether you'd like to defend this matter or not. But invariably, it might happen that as a legal advisor in the public department, I might actually be an admitted attorney or admitted advocate, and the consultation I'm making is actually with an article clerk in the State Attorney's office. So this is a practice that you will no longer find in our current Treasury regulations, but it's also recently been addressed internally through a proposal that we've made, and that is before the National Commissioner, to actually approve certain shortened procedures to settle uncontested and trivial matters without the intervention of the State Attorney. Chairperson, there is again a process that is also touching upon the Department of Justice. There is a process that is currently doing the rounds to try to implement what is called court-annexed mediation. The idea, again, is to reduce summonses, and to minimize the burden of court cases and court rolls. The implementation date on this one is supposed to be December 2015, and SABC has been identified as one of the pilot departments, and we're still waiting to hear on that one, and we're also waiting for an indication in terms of what type of matters would actually form part and parcel of that process. The idea really in simplistic terms is simply to get matters that don't belong in courts to be settled outside court. We are also revising our delegations of powers, and the proposal is already sitting before the Office of the National Commissioner. Basically, we're increasing the levels of decision-making in terms of amounts involved. Currently, we have our provincial offices having a delegation of to 500,000 only. So basically, this means they can't settle matters that are worth settling without sending them to head office if such matters go beyond 500,000. So the delegations are increasing in amount as you go higher. But of course, this is public money. We're not simply giving people a license to play around with public money. So there are certain checks and balances that have been worked into that process. That is also another process that is designed to speed up litigation and to get things that don't belong in courts outside the courts and to save costs. Chairperson, we have, in terms of our performance tools and implementation of a performance rating system, this relates to quick investigation of civil claims at station level. In other words, an incident happens, one quick movement in terms of getting the facts around whether this particular matter would be defendable or not defendable before it reaches the tables of our legal officers. That is one innovation that has been put and pushed into the performance agreements of station commanders. I've alluded to this bi-monthly engagement we have between SABC and the Department of Justice, whose primary purpose is the development on quality management of litigation and to reduce costs. Next slide. Chairperson, our statistics do show us that our biggest risk is unlawful arrest, and we know which environment is problematic here. But what we've picked up out of unlawful arrests is that we, in the main, are attracting unlawful arrest claims based on B crimes, arrest of people for B crimes. We've also picked up an element or a dynamic of collusion between our members and certain firms of attorneys. I must also mention that we were recently engaged with the JP of Gauteng, who raised quite worrisome issues around the things that the courts are picking up in terms of the issues that are landing before them. And one of the issues that they mentioned was this dynamic of possible collusion between certain of our members and the police, and attorneys, and certain attorneys. We are also seeing an element of what we call opportunistic litigation, where attorneys would actually institute action and even go to the extent of issuing summons, and then later on it turns out the would-be litigant is actually not even aware that an attorney is acting on his behalf. Then there is a dynamic that is not necessarily sitting in any document that is related to performance in the police, but certain levels tend to see the instrument of arrest as a performance tool. It is also one of the issues that we've picked up. But to assist our managers, Chairperson, to manage these issues, in other words, the issues that generate claims, and therefore the high levels of litigation and costs, we have what we call a monthly civil claims / litigation report, which is directed at assisting with monitoring and addressing of trends. Now that report is a monthly report that gives you a quick snapshot of what is happening nationally in the department, provincially, and at each and every station. It picks up on each and every claim registered in a particular month in relation to all levels in the police. We can even tell you a story about each and every station just using that report. It also gives a picture of the litigation attracted, or rather the litigation unfolding that month in any court, whether it's magistrate's court or high court, and the outcomes of such matters. But there are challenges in terms of implementation of the report beyond head office level. And in our view, we ought to be now looking at things such as consequential management with respect to lack of implementation of that report. Our statistics chairperson point to the environment of visible policing as the major role player here. What we currently have in the department is a situation whereby the legal division, together with loss management, is the custodian of information and makes information visible every month. But what seems to be remaining as a big question is direct accountability for reduction of claims in the department, and thereby reduced litigation and reduced cost. So we've embarked on a project to look at a prevention strategy that will establish ownership firmly within the environment that is the biggest generator of these issues. And we think in that way there'll be direct accountability for that. You see, the accountability at the present moment is a little bit sideways. You want to debate this subject, the finger always points at legal rather than at where the problem is. To assist the organization, the other thing we're doing is we have a communication strategy to create awareness amongst members and officials about conduct that leads to unnecessary claims. Loss management has a year plan that is addressing this issue, and they go down right up to station level to communicate the message. Recently, we've seen VISPOL coming up, but we still need to see a more structured approach in terms of this kind of process. We also distribute informative material in support of the communication strategy. I've alluded to collusion between some of our members and attorneys. We have certain projects whose details I can't talk about. They are of a nature of a criminal investigation at the present moment. But the organization itself has embarked on what we call a forensic audit around these issues. The opportunistic litigation that I mentioned, where attorneys seem to act for litigants without litigants even knowing, we're also trying to arrest via amendment to legislation or rules of court. There is an old practice in cases that involve RAF, whereby if you sue as an attorney, then you also have to be producing the power of attorney. So this is one of the things we are looking at now to try and stave off this problem. We've sensitized management around the perception, or rather the understanding, that the arrest tool can also be a performance measure, and this is an issue that is also gaining attention. But Chairperson, in closing, I'd like to make this remark. Police work necessarily involves what I call first-hand encounters with citizens. In other words, police work by its nature carries an inherent risk that, when the police perform their work, invariably they'll attract litigation, or a claim or litigation, justified or not. So one of the things that we're encouraging a lot is that before we go in operations and doing our work, it might also be very, very advisable to take legal advice and to take heed of the things we communicate and so on. Thank you very much, Chairperson.
Thank you very much, General Molefe, for your presentation. I think it's a straightforward, clear presentation, putting forward all the issues. Members, questions? Honourable Mbele, Honourable Make, Honourable Molabatsi, Honourable Ankwa.
Thank you, Chair. Just as an opening remark is to welcome the point that jumps out about how the analysis by SABC Legal Services will influence the amendment of the performance assessment tools in relation to using arrest as a performance measure or indicator, because that's always been a bit of a worrying factor. That the arrest rate has gone up and up and up over the years, but we're not seeing attendant progress around, for example, detection or conviction rates, and it leads to a false impression that there's improving performance when we aren't getting to the heart of the matter. So I think that's a welcome and positive outlook going forward. My questions are firstly from page 4. I just crunched some numbers in terms of the settlements versus court judgments and the attached figures. I know it's very, very crude calculations, and I know that the actual situation would be different, because different settlements and different sentences would be handed down in each case. But the very rough calculations I've made is that the average payout per claim in settlements was, in 2012-13, it was 36,000 Rand on average, very roughly, for settlements, and 63,000 for court judgments. In 13-14, it was 49,000 for settlements, 61,000 for court judgments. In 14-15, 39,000 for settlements, and 64,000 for court judgments, which shows that the average, as a very crude figure, is always higher on average for court judgments, which would suggest that going the court judgment route is always going to result in a more expensive outcome for legal services, and therefore it's more desirable to end up or to settle before it goes to courts. Excuse me, it goes to the courts, and so that obviously raises a question around how do you move towards that more desirable situation. So my question flowing out of that is, and it may be an unfair question, because General Molefe has indicated that the breakdown by categories isn't quite there or clear yet. But if you have an idea, what is the percentage of cases that end up in courts, either because of a disagreement on the settlement quantum that was indicated as one of the main reasons, versus an assessment by SAPS on the winnability of a case, and therefore trying to avoid having to pay any money at all, versus an aspect that wasn't mentioned, which I imagine does happen in some cases, which is a litigant refusing to settle from the get-go. They just want to go to court, regardless of what's offered. So what are those rough breakdowns? Because if the majority of them are simply a disagreement on the settlement quantum, it might be the case that simply offering high settlements, even if it's not the initial desired sentiments, will still yield smaller, on average, settlements per case than going to courts, given those crude calculations that I could make from the figures here. My second question is basically knowing the analysis of what the risk factors are. How does legal services analysis feed into the performance management within the HR processes of the SAPs? I mean, it is hinted at in terms of remedies like a communication strategy to create awareness amongst members about conduct that leads to claims, but a communication strategy is too diffused. You need to be able to, from the analysis, say there's a particular problem either in this area or in this operational environment, and therefore those trends need to be linked to the performance management so that we get more direct accountability between the members or the units or the stations that are causing a disproportionate amount of the problems for us. And then it must reflect in their performance reviews and their performance management so that if people need more intensive intervention on code of conduct or whatever the case might be, or ultimately to be managed out of the police service if they aren't responsive to the accountability mechanisms. So do we have that strong link between the analysis and information that you get and how the SAP's HR process then manages those risk factors? Because that's really what accountability comes down to, is every misconduct must result in a direct and effective sanction. I think that's actually all I had for now, Chair. Just to flag, obviously it is very concerning to hear that collusion may play a big factor in all of this, because that's obviously detracting from the ability of the service to operate effectively. So if there is collusion and opportunism of that sort, then it must be clamped down on and rooted out.
Honourable Markey.
Thank you, Chairperson. Page 3, I think the percentages there exposing my mathematical limitations. Maybe I need to get some change for my school fees from my principal. I can't seem to get my way around the percentages that are there. If maybe I can't relate them to what is written here. The 55.7, the plus 2.1. If that could be clarified for me. And then on page 5, the invoices received from the Department of Justice and Constitutional Development in terms of the legal costs. If I was to be given an example, what actually would those be? Do you have to pay the state attorney as in terms of salary, or what the portion of the salary must come from the police or whatever? The last question would be on the amendment to the Organs of State Act 40 of 2002. The process, where is the process now? And what needs to be done? Or when can it reach us? Because as the General explained, that would reduce the costs tremendously. Thank you, Chairperson.
Thank you. Honourable Mkonku and then Honourable Malabatsi.
Well, thanks a lot, Mr. Chairman. I've got just two very short questions. One has to do with bullet number 1, 2, 3, 4 on page 7. The implementation of communication strategy to create awareness amongst members and officials about conduct that leads to unnecessary claims. My question is, would this not work better if this was to be part of the training curriculum of the members at college level, so that from that level they know what the do's and don'ts in terms terms of the legal framework. There's the last one also has to do with the last bullet, legal advice prior to operations, as to how this is actually implemented. Thank you.
Thank you, Honourable Member. Honourable Molabatsi.
Thank you, Chairperson. Seeing that the suspended National Commissioner has decided to go the legal route, who will SABC be paying her legal fees? My second one, you have an increase in payment of compensation. To what do you attribute this increase? My last one, what are the types of cases that end up in court judgments? Thanks, Chair.
Thank you very much. Honourable Members, those are the questions. Thank you. General Molefe, over to you and your team.
Thank you, Chairperson. I would just like, before General Molefe starts responding together with his team, Brigadier Groenewald, Sutton, and I shall also make certain comments, only refer to a very important aspect. And that is, and I've seen it also in the British environment, whether arrests should ever be a performance indicator or not. Now, I just leave it there for members because probably everybody will have an own opinion on it. Now, although it was a research in Britain, but they have found at some point that if you make it a performance indicator, people go for arrest, but you actually increase the risk for this civil kind of claims. But I leave it in the behold of members of this committee. This is always a very, very difficult question, whether the number of arrests should be a performance indicator as such. I would just also like to mention one thing in this regard. Members will remember the legal cost scenario actually emanated from our presentation of the Portfolio Committee, where we referred to expenses. The civil claims scenario emanated, and I think we also provided, Chairperson, I hope you received it, a comprehensive letter of some research which a committee wanted in terms, not research, analysis regarding the aging of the claims, emanated from the performance indicator of legal services, where it was argued at the time that as it is maybe worded in our APP at this point in time, is of a preventative nature, which is actually in the visible environment because it's a behavioral aspect. If you want to actually measure legal services, it is a retrospective, a backward-looking scenario regarding how they dealt with the claims, where the legal cost comes in. One very important aspect, and I think General Molefe as a legal expert, and we've been working together for years on this thing actually, is the fact that when do you settle and when do you oppose? It is, and all people with legal knowledge will know that. On the one hand, you can go into a cost-effective kind of model, but on the other hand, you must also look at what were your results when you opposed. If you look at the financial statements, page 416. Now, I do not say all of those figures are when we opposed. There are other reasons also for cancellations and reductions. I just had a look and I did a similar calculation while I was sitting here, Honourable Member, in terms of the ratio between, because to a large extent it's an inflow, throughput or transformation output model. You must try from a litigation point at least, obviously also from a preventative point, to balance out to stop the growth. I have looked at the liabilities incurred vis-a-vis the liabilities cancelled, reduced or paid. In 14-15 it was 99.42%, more or less equals out. The previous year it was 62.56%. The year before was 43.31%. meaning that if I look at the real values, not percentage-wise, liabilities cancelled in 10-11, that is after letters of demand were received, was 660 million. 11-12, 2.7 billion cancelled. I'm not even talking about paid, because that's less, but anyhow. In 12-13, reduced cancelled, 2.8 billion for Bravo. In 13-14, 3.46 billion. In 13-14, in 14-15, 9.2 billion. I don't say here, please understand me, that everything was because we opposed it in court. But in the legal process, there are reductions taking place. We've also done an interval analysis, but I don't want to take up all the time now. An interval analysis to see how many, Walter, can I just get that interval analysis? How many claims contributed to what portion? The one that I did this morning. And to share with members that approximately 694 claims, if you look at intervals, contributed to 15.4 billion of the 26 billion. What it also shows one, to a large extent, is that sometimes you get a person, they arrest that person, the person had a business, the person said, I'm now losing the income for the next 20 years, I claim 200 million. But it's astronomical, it's sometimes totally out of bounds, and eventually such a person will only be settled, the claim will only be settled for 5 million or 800,000. So I don't counter-argue anything here. All I'm saying, it is a highly complex matter, and I think going forward, if we can convince the state attorney to assist us with processes that are shortened, more compressed, that has more viability in it in terms of numbers, and we could deal with this in an enhanced manner. Remember, the nature of our business, to a large extent, generate claims. Obviously too much or too many. But the fact of the matter is we have to get those processes running in this regard. But I'm going to hand over to General Molefe in order for him to relate to the specific questions. But we've been sitting with this, analyzing backwards, forwards. We looked at estimates, we looked at letters of demand, we looked at when we went to court and so forth. But, and I will maybe, if necessary, just make a remark, but General Molefe and his team will now deal with it. Thank you, Chairperson, for allowing me.
Thank you, General Schutte. General Molefe.
Thank you, Chairperson. The question of Honorable Mbele going to court is more expensive. Perhaps we could be looking at a more desirable kind of direction. I'd like to say, Chairperson, the tenor really and content of the presentation is actually pointing to that. I think I've alluded to things such as, how we approach settlements, first and foremost, the investigations that we do in terms of establishing the defendability or non-defendability of each matter, the principle of shortened procedures, and the big principle of alternative dispute resolution that we are looking at with the Department of Justice. There's been a lot of debate around this. You will notice that SABS in the main attracts a lot of claims on unlawful arrest, but you also have things such as collisions. I just want to use that as an example. Those would be one of the easiest kind matters that can be resolved out of courts without, and that of course would mean saving in terms of cost. So moving forward on the principle of alternative dispute resolution as well as shortened procedures, we see opportunity in terms of implementation as a starting point around claims such as those. But of course, We've been around and we know what is involved with things such as unlawful arrest. It is also possible to settle quite a lot of those, because what we have behind us is an understanding of the law and the experience. But I'd like to say it's been quite a journey. The debate on cost visibility was something unheard, not only in SABC, but in state attorney, not until at least about 3-4 years back when we started engaging. We've engaged, we've moved, we've changed our systems to accommodate the principle. But we're still lagging behind on this one because of our dependency on another department. Where we are at this point, we are where their financial people are beginning to grapple with the issue. We still don't have ready results on this. All I'm trying to say is that we are walking straight and in line with the thinking that is saying, let's see what is it that we can keep out of the courts. We know police work will attract risk, but there's things that we can manage. We can manage the litigation process. It is capable of management. Yes. And then, how do the things that we do feed into HR performance tools of SABC? Chairperson, for the first time, this department has made visible what looks like a performance indicator that is organizational, that seems to be capable of being made to cascade down into performance agreements of managers. That's exactly what has happened. That is why at some point I alluded to perhaps one of the things to look at this point in time is consequential management, because it's there. It's now an issue of performance at all levels of management. But in addition to that, civil claims, especially the factor of unlawful arrest, has been identified and highlighted as an organizational risk. And the debate that is currently taking place within the Enterprise Risk Management Committee is a debate that is trying to find ownership. In other words, who are the risk owners? It starts there. Let's get the risk owner to take charge and deal with these issues. That is where we're sitting. And the strategy that I spoke about, that is actually trying to bring this thing out and get it right, is actually coming close to that kind of thinking. The next question was, the remark about collusion and opportunism. It is indeed being clamped down, Honorable Mbele, but I need to caution, the presentation is not saying that this is the main issue. It's a dynamic that we've picked up. It is one of the elements, but we cannot say it is one of the main issues at this point. And it is being addressed. Do we pay state attorney salary? Brigadier Satin, I'll want you to respond to that one, but we certainly don't pay state attorney salary. What we pay, remember state attorney is our lawyer. They will pay the capital, they will pay attendant costs, then they will account to us at the end of the month, then we pay. But there's also the element of, expenditure as well, around expenses as well. Yes, those are for their account, I'd like to believe, yes. Can you go on?
Thank you, Chair. Honourable Member. Can we just perhaps go back to that slide to clarify the percentages? Yes, that is the one. Maybe I just would like to say that the reason for that particular slide is it is actually compiled in relation to the whole question of legal expenses. What we try to achieve with this slide is just to show Chairperson, if there's an increase in the number of claims that we registered annually, and we can also succeed in finalizing more claims. For example, finalizing in the sense that it needs to be paid, whether it is an out-of-court settlement or a court judgment, one can also then expect an increase in legal cost due in this regard. So if we just look at the percentages in the first line, what we try to do there is that we just look at the number of claims registered in 2012-13, which is 10,777. And if you compare that number of claims registered in 2012-13 and compare it with the previous financial year, 2011-12, there we received 10,552. It is an increase of 2.1%. Now, if we now just follow that specific first line to the next column, if one look at the number of claims registered in 2013-14, which is a little bit less than we registered in 2012-13, there's a slight decrease of 3.2%. Now, again, if you look at the last year, 2014-15, we registered 12,670 claims. Compared to 2013-14, it is an increase of 21.4%. So it is just to make sure that we understand how we get to that percentages. And the next line, what we compare there is not the amounts paid, the total amount paid for a specific financial year. What we compare there is the number of payments made. And we express that in terms of percentages. Again, if you compare what we paid in 2011-12, for example, and compare it with 2012-13, that is an increase of 55.7 number of payments. It also applies to 2013-14. If you compare that with 2012-13, an increase of 41.2%. And the same then again applies to 14-15. That shows an increase of 2.02%. Now again, the same principle now applies to legal costs, but there we look at the actual amount paid for legal costs concerned and not the number of payments. Chair, I just thought of sharing that we know that the state attorney renders a service to all organs of state. Now, when we instruct the state attorney to render legal service on behalf of SABC, there will always be, of course, legal costs involved. But the state attorney don't charge us for example, his services is actually free of charge, to put it like this. So in other words, he's also a public servant paid by the Department of Justice. So we don't pay their salary. But once the state attorney have to pay for certain stuff and there's expenses involved, let us, for example, say cost of counsel, correspondence, and even if we have to serve a summons and the sheriff have to go and serve the summons in respect of a claim by the state, for example, there will also be expenses involved, which we as the SABC will then eventually have to pay. So what happens in practice of the 10 state attorneys' offices among in the country means that all the state attorneys' offices, when they start to perform legal service on behalf of SABC, and there's certain costs involved, they will first pay it from their suspense account, and then on a monthly basis, all those claims are submitted to the Department of Justice and Constitutional Development. And then they will consolidate all those claims and submit it to SABC for a refund. And this is what we would like now to make sure about, is to say that we would really like to know exactly what legal costs are really involved in terms of the cost visibility project. So this in a nutshell, I just try to summarize in a nutshell then how to interpret the stats, to just then make the point that when we succeeded in finalizing more claims through payments, there will eventually be more legal cost involved that will be due as well. Thank you, Chair.
Right, is that all the responses?
No, Chair, can I just deal with what is remaining? The question on what, or rather offer winnability as against the refusal to go to settle as a factor that takes us to court. The breakdown on that one, we cannot really give any information at this point on that one. But let me mention that settlement is not really a thumbsuck exercise. Yes, it's actuarial, like you say, General Skete. It is also a factor that is driven by understanding of issues of liability. You know the law. You know you are liable, and to what extent you are liable, and if you are liable, what are the possible costs around your understanding of the extent of your liability. Are we going to pay for the legal costs of the National Commissioner, as it is alleged she intends to sue the department? We have a policy in the department, Standing Order 109, and I do not think it does cover the kind of legal action that is supposedly being debated out there. Then, why do we pay compensation payments? Compensation payment, there is just a term given to what we're paying as capital. In other words, we get sued. If some court says you are liable, we pay that. Or if we are of the view that there is no need to go to court on this one, we're indeed liable, then we pay that one. It will get that name tag, compensation payment. Communication strategy, can it not work better if it is not part of the curriculum? I think part of the basic training curriculum also involves training in terms of the legal issues that relate to policing. It is already there. So what is being done is to actually support members now when they are now out there in the business of doing policing. Legal advice before operations. What we are trying to say there is that the legal advice is available. We have instances of where it is being utilized and utilized optimally. And one of the perfect examples whereby we feel our operational people are actually now really getting involved with the kind of services we are providing would be the Fiela operations, which are driven by the nut job. We have a presence there, the nut job, and there is a culture that is fast developing that we get involved and get to be requested to assist before things happen. Chairperson, I suspect I've covered all questions, but if there's anything that I've left out, I'd be glad to be reminded of it. Thanks.
General Schutte, and then I'll allow just 2 members because I want to finish this section in 5 minutes. We must go to the next section. General Schutte, yeah.
Just maybe without going into a huge explanation, when you do, members will remember when we do the budget, we have those score items. You have current expenditure, under current you have for personnel expenditure, which is also compensation, then you have goods and services, then you get to the transfer element. Under transfers you have payment to agencies like SABC and those people. But also under that you have transfer payments to households. The moment you do the justice payment, let's say for compensation and award, even in most instances a cost award, you pay it to justice as a transfer payment because it's an unrequited payment. You don't procure the goods now from justice per se, because it's a compensation payment if the award was given. If you procure the service from justice, it's under goods and services because you received the legal service. All I want to say to members is it will also affect where you vest your expenditure. The one, if we have to pay the honourable member because she has been illegally arrested, it will be a transfer payment. If we have to procure the chairperson because he is our legal service provider, we'll pay him under goods and services because he provides a service. The other is merely a transfer payment to a household. And the cost visibility surrounds that whole transfer environment where we receive then the claims from justice. Because the debate could even go further. Should we break it more down to say what was for medical expenses, what was for future hospitalization? It's a highly technical thing, but that's where the cost visibility. We just feel if we go drill deeper, do more data mining into it, we can probably also devise for those specific elements which will affect the summary. Thank you, sir.
I saw Honourable Mark and Honourable Longu.
Yeah, thank you, Chairperson. The question on the Organs of State Act.
Honourable Longu, anything from your side? The final question?
Yeah, no, thanks. No, what I wanted to find out, Chairperson, because I'm very much worried about these figures, some of these figures. I wanted to find out, not unless, Chairperson, if it is a plain question of law, because the question of law definitely needs court to make a ruling on that, depending what level of the court it is. But if I may ask a question, is there any kind of data keeping, or you just get claims coming from KZN, Eastern Cape, then you just issue payments without necessarily checking out what really may brought about that particular claim? Is it an illegal conduct by members? Because if it is not followed like that, I suggest there can be a number of rock men and women in the service who can actually drain the state badly without us coming to the proper caping of this. I think the stats talk of its own. If you take 10,434 and you have got 5.9 billion, then I can tell you, it's very clear. Someone is making a kill of money that ought to be focused in terms of delivering service to the people. So I just wanted to find that, because the reason why I'm raising that, Chairperson, if you have got one member repeatedly found to be, for example, conducting unlawful arrest, that must bring some kind to say, no, something must be done to follow this particular member. If then there is no such follow-up, we will be just putting money to the endless pit. And that can actually bring us to a standstill finally. Like what we have seen with health, for example. Thanks.
Thank you, members, for the questions. General Molefe.
Thank you, Chair. Honourable Marcus, question, amendment of the Act. The Act is actually under the control of, administered by the Department of Justice. So what we've done was to make a proposal to the Director General as well as the Minister of Justice through our own DG, National Commissioner, and the Minister. And that is where it is sitting at the present moment. I might as well mention that it does have the support of our counterparts in the Department of Justice who sit with us in that bi-monthly engagement that I've spoken about. The second question of Mr. Mhlongo, can you deal with it, sir?
Chair, if I just think about the last question regarding legal cost, I think it is very important to know that once the State Attorney renders a service to us and there's legal cost due that needs to be paid, there's a very strict process of certification at the Department of Justice at the State Attorney's Office to make 100% sure that all the legal costs indeed are legally due. In a lot of these matters, are taxed by the tax master. Normally there will be also the State Attorney will sometimes also be present there to make sure that whatever is eventually claimed for payment from a successful litigant is properly taxed. So there's really a huge certification process involved prior SABs receiving those invoices for payment and refund. So in that sense, I would suggest that there's already a control mechanism in place to make sure that whatever we received in terms of invoices and legal costs due to the department, that it is really properly attended to. Because the state attorney is also very much involved to make sure that once there is counsel appointed, legal fees are negotiated, and then they will also certify that those legal costs that needs to be paid is in terms of the fees agreed upon. So indeed, the cost visibility project would like to aim at to make it visible, to make sure what are the legal costs paid in terms of each and every individual claim that we registered on our systems. But we are not yet there, Chair. This is exactly where we want to be, to account to that extent mentioned for all the expenses that we have to pay. But I'm convinced there is no payment, no court judgment, no out-of-court settlement that is just, there's no court judgment or settlement without merits being available to make sure on merits. So there's no doubt that a due process is followed to make sure that all these costs that are eventually paid can be properly accounted for.
Thank you very much. We've come to the end of this section on legal expenditure. I think it's important to note a few matters. The one is we welcome the fact that there is a movement to ensure that we get, to use the word, the cost visibility going forward. But also, again, visible policing, that's the environment where most of the claims are coming from. So it deals with training, what's happening at the college, what is the approach in terms of interaction with the public. So that's a matter that needs constant interaction. But I think the new program 5 that was indicated here today of interventions, quite critical. So if there's provinces or units where there's a huge increase in legal risks, it must be addressed, I think, from a proactive point of view, but also in terms of interventions. So that's quite critical. Then the question of maybe corruption, collusion, I think it's quite critical that priority crime unit should look at that, because it's very much like other litigation in the medical field, where, and I think it's important that we address this holistically. So there's a lot of issues that still needs the attention, but I think in terms of the presentation that we received today, there is good progress. So we will commend the legal unit on these progress matters, and to ensure that we, I think from a, let's say, management point of view, that SAPs contain that liability, because it's big figures, and I mean, in the end, as one of the members indicated, that can be used for service delivery, and so that's an issue that we must keep an eye on. So in the new year, we will again maybe invite you to give us an update on progress in that regard. Thank you very much. We will then go to the next briefing, briefing on Tetra, Eastern Cape and Gauteng. And then the last one will be PChem. General Shezi, over to you. Honourable Bele.
Chair, can I just indicate, so as not to appear rude, at some point I'll need to slip out because I have a scheduled meeting at 2 o'clock. My apologies. No.
You're welcome. General Shezi, you're welcome.
Thank you, Honourable Chair. Thank you, General. Chairperson, the presentation is focusing on the complete Tetra solution as it was requested by the committee. I have divided the presentation into 2 sections. I'm going to first talk to the Tetra Gauteng, and then I'm going to discuss the Tetra Eastern Cape, and I'm also going to focus on the questions that were broadly asked by the honourable members in the previous sessions on Tetra, as well as concluding with the way forward regarding the Tetra solution. Thanks, Kevin. And the next one. And the next one. This one. Chairperson, I would like to take a little bit of time to talk about the Gauteng Tetra, because it is the first one. From compared to the Eastern Cape one, it doesn't appear to have a number of challenges as the Eastern Cape Tetra solution was, but I thought it was important that I highlight on the same scale the costs associated with the Tetra Gauteng, since its inception from the financial year 2012-13. You will notice in that presentation, Chairperson, that in 2012-13, what was invoiced or what was paid to the supplier of the Gauteng Tetra, which is Alcom Motomo, was 30,792,000. In the next financial year, we had spent 13,944,000, and so forth with the rest of the financial year. But perhaps maybe before we even go on further, Chairperson, it suffices to say that the Tetra contract was awarded to SABC for the period of 3 years, with a possible extension, of course, given the dynamics that it was. So you would notice, Chairperson, in there that the current Tetra contract is in its 4th year, with a termination date of next month, which is December 2015. In total, year to date, the amount that has been paid to the Tetra Gauteng solution to date is 117 million. The next one, please. But this slide, Chairperson, will talk to you a little bit of the sequence of events, a little bit of a timeline in terms of the Tetra Gauteng. There was a switch scenario, Chairperson, if you would recall, that there wasn't any maintenance done on this Tetra radio communication network for Gauteng because of the disparities or the options that were given in the contract at that stage to upgrade the switch. The maintenance of the Tetra solution within the Gauteng provinces was high in relation to what it would have been on a normal grounds, but the reasons that were alluded to this maintenance was the unavailability of the latest or the upgraded switch. So what was to determine, following even the discussions from this committee, was the way forward that SABC would take in terms of the switch status of the Gauteng Tetra solution, which Gauteng Tetra solution then, Chairperson, was approved in March 2015, about 9 months ago, and that project is continuing. The project anticipates to conclude in next month, Chairperson, because the assembly point has been in Germany. Currently, the technicians from the sub-site are in the United Kingdom, to finalize the training on the utilization of the Tetra, as well as the implementation for the Gauteng solution. The order was issued to the supplier in March 2015, implying that towards the end of the contract, the supplier only had 9 months to can ensure delivery of the services. The switch itself was made a provision within the contract, but the contract made it an optional matter. That is why, amongst other things, there was a delay in the finalization of the upgrading of the set of the switch for the radio communications within the Gauteng environment. The day-to-day maintenance is still ongoing on the existing infrastructure. One of the questions that was asked, Chairperson, was whether the current radios could still operate, whether there is sufficient communication, whether the police were not having any challenges. Until the switch was upgraded, there has been a day-to-day maintenance, which is also part of what is the contract that has been awarded to the same supplier. The next bullet talks to the Tetra MSO, where the upgrade, or perhaps the current solution that is existing with a renewed one, which we know that it will be commissioned in December. Perhaps that's why the reason for the last bullet, Chairperson, might then warranty the maintenance part of it. It is among one of those contracts where the installation or the commissioning is at the end of the contract period, which then might, by virtue of it being in the last end of the financial or the contract year, might warranty the extension to ensure that there is operationalization and there is sufficiency in this part of the process. The current challenges with Tetra Gauteng, as I started, Chairperson, there is no necessarily any threat. It is a project that is on schedule. It is a project that is working. There has only been the issue about the switch. The switch has been addressed. The switch is just a report that we had addressed with the report that I'm providing in there. But one of the questions that I had from the honorable members was the vandalism at the high sites. At some point in time, there were queries about radios that were down in the Melanesian area. I think it was sometime in March that I was asked that question. That question has been, the vandalism items have been taken into consideration. Currently, we are in discussion with facility management to ensure that all the high sites within the Gauteng environments are protected accordingly. The last point, the chairperson is talking to the expertise of the people that are doing the maintenance within the Gauteng environment. The people that have been employed in the Gauteng space or in the radio communication space are retiring. There hasn't been any necessarily recapacitation of the new capacity because suddenly we had relied on the supplier competencies, but we have now embarked on ensuring that as we award the contract, we also ensure that the training is embedded in it so that the skills are transferred internally. It covers all the 67, it's got 67 high sites in Gauteng, covering all the 142 police stations within the Gauteng environment. Thanks, Kevin. This is the one solution that I'll spend a little bit more time on, Chairperson, because it was the actual point of discussion for the session for today, the Tetra Eastern Cape. I thought it was sufficient, Chairperson, to provide just a little bit of a background of how it had started over the past 10 years to modernize the radio communication infrastructure. Police had been using the old walkie-talkies, the old type, old style, where people were to speak in various instances on those old models of phones, in spite of the advancement that has happened in technology. But for the past 10 years at least, there has been serious engagements with the various providers of the solutions internationally to ensure that SABS get a solution that will provide a secure communication networks throughout the country for the police officers. You will see, the Chairperson, as I refer to the CSIR report in this manner, because I had promised that when we come the next time, I shall provide a report. The report is also part of it. I will quickly skim through that so that I don't take part of most of the Chairperson's time in this instance. But SABS initiated this project in line with the internationally accepted best practices. This presentation will almost summarize what the contents of the report also say, so I don't have to repeat all the 32 pages that are contained in the CSIR independent evaluation. But the third bullet is the most critical aspect, Chair, because one of the questions that was asked is, how come are we not concluding the Tetra Eastern Cape? What has been the delays and what had happened? We had to go and find sufficient details and motivation and all the engagement to see what were the actual challenges in terms of finalizing the project. But one of those that had come to the fore was the acquisition of the radio sites. As I refer to that CSIR report, Chairperson, I will indicate in that specific site the acquisition of the radio sites, which is still a current concern. Chairperson, Chairperson in his capacity also asked whether the high sites that the police were utilizing were in the leased properties, in the leased areas, or were they in the state buildings at some point in time. We did that exercise, Chairperson. We determined how many of our high sites are in the leased areas, and it's over 70%, Chairperson, of our high sites that are in leased areas where we have to work on the registration of servitudes, but that process has already started with the Department of Public Works. We just have to ensure that that process is given due attention so that all the registration of those sites, or servitudes as they are called, happens at the pace that we want to take it. We took this Tetra scenario or status quo to CSIR for evaluation, for independent assessment, functionality, and all those things, and we do then have a report which is before the committee this afternoon. This one talks to the timelines, Chairperson. One of the questions that was asked was, when did it actually start and when did it actually end? You will see in this slide, it started in 2006-07 financial year, where the request of information was published, within the industry to see how many of the suppliers would be interested to provide what type of solution. That process started. The bid was published a year later in September, and the contract was awarded another year later in December of that year, on the 11th of December in 2008. But it took about 4 months or perhaps 2 months, and on the 20th of February, the order was issued to the company. You will see as we go to the report, the order that was issued to the company was for the total value of the contract. Now, the total value of the Eastern Cape was at 920 million at the time. So this is part of what had created the disparities within the Tetra solution. But the timelines goes on because of the first installation started with Intercom, the company that was awarded the contract in 2009 until 2010. But in 2011, Another bidder which was competing with Intercom launched a High Court challenge to the processes, to query the state in which the Tetra solution was awarded to the another competitor, Intercom. That process took long in the investigation. Perhaps at some point, General Skate will also give a little bit of a summary as to the outcome of the SIU, which are also covered a bit in portion of what the CSIR has done. In November of the same year, 2011, the Portfolio Committee visited the sites at Eastern Cape to just verify for themselves how the investment that had already been done in Tetra, how far it has gone, what were the conditions of the facilities, and all those questions that were asked, including all the equipment that were found in the various stores, to say what were the state and the intention of SABS going forward. So this one talks to just a time frame, Chairperson. I'm not going to talk to just each one of them. The next one. That was a contract value. The order was issued then at the time, Chairperson. In case of the Eastern Cape Tetra, the contract period was 5 years. The next one. Now, this is a very critical slide, Chairperson, because I did not repeat each one of these values in each of the presentations. But this is the total breakdown of what the committee wanted to know about what had happened, how much has been paid to the level of detail. I have the level of detail to the last equipment, Chairperson, available. We have done a lot of work since the Tetra. So we've compiled all the reports. So all this, the supporting document can be made available to the committee should they be needed. But this breakdown from 2009-10 will then tell from the budget that was allocated to the Eastern Cape Tetra, what was the portion that was paid and invoiced, and for the subsequent years, how much thereof was also paid. You will take note for the duration of the contract as it was awarded in 2011, Chairperson, in 2009-10. We had embarked on the payments in accordance to what the order was. But if you look at the little explanation just after the row of 7 there, a total amount of 445 million was paid to Intercom. This is all the total of what has been paid to date. But you'll see there's a little bit of a disclaimer at the bottom there that from that total, what has been paid, there was a 10% retention amount that was outstanding. The 10% will then talk to the amount that will be paid to the supplier once the solution had been commissioned. Now you would say the order was issued for 920. The services that were rendered and the equipment that was delivered amounted to 445. It would then mean there was an amount of work that was left to be done for the remainder of the balance, which balance we will reflect to say what type of work did not happen, and it is also contained in the CSIR report. The next one, please, Kevin. Now, this slide, Chair, it talks to the breakdown of where the money was spent. This is an estimated version. It's not to the last rand, but like I had said, that with the Polfin reports and all the other documentations that we have, we can actually provide the records to the last cent there. The different colors will denote the amounts, like 318 million that will talk to the high site development. Now, these high site development are those areas that host the masts, that will allow the transmission, of the radios from the operator to the control centers and so forth. And those are the microwave links, the latest microwave or the satellite types of dishes, almost that are installed in the various identified areas to ensure that the transmission is sufficient for the police to be able to talk to each other during the processes of communicating to one another. The amount that is written in red will talk to the upgrades of the 10,111 centers, or the PE and the East London metropolitan areas, and it will talk to just that breakdown of how much money was used for what type of service. The next slide, please, Kevin. Now, Chairperson, this slide is the slide, I could have just provided this slide alone. This slide would have given almost all the questions that were asked about the Tetra project, because you will have a look, Chairperson, under the items in this picture. It says, what was ordered when you wanted to do the site construction? How many parts of equipment how many sites did you identify to do the site construction? What was entailed in the site construction and so forth? What was supposed to be erected in terms of the masts and all those questions that we'll ask. Then the subsequent ones will say, okay, the base stations that we're going to be then erected in those sites that are already prepared, and so forth. So you will see, as you look per item of those lines, in terms of the site construction, 212 items of equipment were procured for those purposes, but only 51 were delivered. And from the 51 that were delivered, all 51 were installed. It means the company, from the order that was given, the outstanding of the equipment that were to be delivered in terms of what was to do to the site constructions were 161 items. So for each one of those, we'll have a map of what was ordered, what was delivered, what was installed, what is currently in storage, and what is still outstanding. So you will see, Chairperson, when we look only in that column that says in storage, all those equipment says that talks about the Tetra base stations for the sites, the microwave links in the equipment says the power supplies and the rectifiers and so forth. Those, the mobile radio devices, the handhelds, all the towers, all those elements there are all those equipment that are in several stores around the country. The presentation also tells in which part of the country or the storage is what type of equipment. When the CSIR did the independent evaluation, they took some time to go to the Eastern Cape and to also locate for themselves where each of those items are and to what value those items would cost. So I thought it would be a nice snapshot to show, to say that what is it that was ordered, for what value it was, as the previous slide had indicated, summarized, and then what has been commissioned, what is in storage, what is still outstanding. So you will see in the last column that says outstanding there, Chairperson, it's all that's supposed to be provided by the company that is not there yet. It's all part of the remainder of the 920 million that is still to occur, that is due by the company. But what is in storage is what we already have, we had already paid for. In some instances, it must be commissioned and operationalized. In some instances, the sites must be prepared and made ready, and all the challenges that were available or that were experienced from the 29-10 financial year when this project started. The next one, please. Now, the following 3 slides, Chairperson will then tell to say that in Gorston, in 10-111, for the Eastern Cape Tetra, for what was paid for, what will you find? And then it lists all those. In Woodburg, for example, and then it will provide all those details. You can continue, Kevin. And the next one. Okay. But what about the Tetra, the status quo of Tetra Eastern Cape within the SABs? For the Eastern Cape Environment Chairperson, 2 new 10-111 centers were constructed. The one is in Scoreston, the PE, and the one is in Woodbrook in East London area. The third one, which was supposed to be in Tata, that was cancelled because of the apparent non-performance by the contractor, by the building contractor. The site was made ready. I'm going to quickly refer to the CSIR report just to show part of what I highlight specifically because it's in that document, and then show what has been prepared and what did not actually take place. In the Port Elizabeth, equipment was installed completely and configured, and it worked. In the Seaview high sites, amongst those sites that also needs to be constructed. Those sites that were completed, Chairperson, and commissioned, the second bullet there, we'll talk to them. The 14 Tetra sites which were completed are all those, including Nelson Mandela University, all those high sites at Uitenhage and Police Station and Guadwesi, and so forth. Those were the sites that were operationalized during the 2010 World Cup. The Chairperson will recall that amongst other achievements that were read and were cited was the efficiency of the Tetra communication system in Eastern Cape during the World Cup. The police were all excited about the Tetra solution, which was switched off to their disparity after the World Cup for the reasons that we'll cite just now. But they work, they are in operation, they are simply working. During the funeral of the late President Mandela, those 14 sites in PE were also operationalized, and the coverage was extended, including additional sites that were prepared with the Metro Ethernet, East London, Tata, Bazia, to just ensure that there is sufficient coverage on radio comms by the police officers. Okay, the next one, this portion there, Chair, is talking to the mediation that the current company Intercom would like to have engaged on. The company is of the view that it was not because of its own doings that the project was delayed. It was because SABS did not make the sites ready for it to be able to make the determination and to finish off. So SAP would say, but it was also not my problem that the sites were not ready because DPW didn't come on board. And DPW will say, you know, all those stories, but all these are captured in the report. Chairperson, they put it in context to say why were the delays and the extent to which these delays on making the sites ready had an impact on those ones. And the fact that the environmental impact analysis have got a time frame, but that time frame, if it lapses or it expires, you know, PWD has got to re-embark on the process to get those sites ready, and all these things delayed on getting this project finalized. So the last three bullets talk to the cost that says, what are the estimated costs to can operationalize the currently installed equipment? There was a question that was asked sometime by the honorable members. I can't remember who exactly at the time, Chairperson, but many a times this question comes forth to say, if you were to make sure that this thing is operationalized, you know, for the sites that have been made ready, what will it cost? You know, so CSIR has embarked on this. There's those values on the table there. And then, so those sites that are outstanding, what is the amount that are still to be paid? I'm going to quickly refer to those in elaborately as they are captured within the CSIR report.
This is only for part of the province.
And that is just, Chairperson, part of those, of the 14 sites as I will talk to them, and not necessarily the whole of the Eastern Cape. Remember, I will go through those reports, only those ones